If you're arrested for a new crime, you can be held without bail for up to 90 days.
Mr. Kearney just wants to make sure that he doesn't give these witnesses veto power over him being able to investigate the Reed case by virtue of just showing up.
Good afternoon, Your Honor. Elizabeth Little.
Good
Also,
afternoon.
on behalf of Ms. Reed.
Good afternoon.
She got caught lying. She's an absolute liar. She's a deranged individual.
Not her phone sent those messages. She absolutely denies it.
Have you spoken to Officer Crump yet?
No, I have not spoken to Officer Crump.
Don't you think you should?
Not really, Judge.
All right.
I interpreted if you wanted to go far enough away not to be a violation of.
For pretrial detention, it's a physical danger standard.
And he has a car. God knows he can get his hands on another weapon.
Good afternoon, Your Honor. This is 23313 as well as 2443, the Commonwealth versus Aidan Kearney. Can I have counsel identify themselves, starting with the Commonwealth?
My name is Robert Novak. I'm a Special Assistant Attorney General. I'm filling in for Mr. Mello, who's ill.
All right, Mr. Novak, good afternoon. Welcome.
Hello, Your Honor. Timothy Bradle on behalf of Aidan Kearney. Before me, Judge, in custody for the record is my client, Aidan Kearney.
I believe we're here because the bail revocation period is up. We need to address that. Mr. Bradle, there are also 2 new indictments against your client. Do you wish to have him arraigned today?
I do, Your Honor. Thank you for
All
asking.
right.
I appreciate it.
So let's do that first, Mr. Clerk, and then we'll deal with issues relating to bail thereafter.
Mr. Bradle, does your client waive the right to a formal reading of these indictments?
Yes, we do.
1 count of intimidation of a witness, 1 count of disclosing the contents of a wiretap. Mr. King, how do you wish to plead, guilty or not guilty?
Not guilty.
Thank you. You can have a seat. Question of bail for both cases.
Yes, Your Honor. The
Go ahead.
Commonwealth will be requesting $10,000 in cash bail in certain conditions. The first one being that the defendant stay away from the alleged victim in the case. Secondly, that he obey all outstanding restraining orders regarding the victim. And thirdly, requesting that there be a GPS monitoring with just an exclusion zone as to the victim's home, place of work, or schools that her children may attend.
All right. There are a number of different victims in connection with both matters, correct?
Yes.
So you're asking for a stay away, no contact with all named
Yes.
victims. And the GPS exclusion zone would relate to all as well.
Yes, it's not required, obviously, to keep the defendant in home or just away from the particular victims in the many cases.
How many separate victims do we have? I haven't gone through and identified
Thought there
them.
were like 8.
Okay.
Is that correct?
And why is the Commonwealth requesting cash bail as well?
The reason that we're asking for cash bail, Your Honor, is because the new charges are exceedingly troublesome. The defendant has already been charged with the multiple counts of intimidating a witness, and it's obviously that he has a proclivity for continuing in this conduct. If I could go over a little bit of the background of the intimidation, the new intimidation of a witness case, Your Honor, this occurred on December 23rd of 2023. At the apartment of the alleged victim, who was Lindsey Gaetani. When the defendant came over knowing and for the purpose, because she had received a summons to appear before the grand jury. When he appeared at her apartment, he told her that when she went to the grand jury, she was going to tell them that she knew nothing about the case. He further told her that he wanted to take her phone and go through it to look for and to erase any particular contacts and data that she might have regarding the matter.
Okay.
He threatened her in saying that if she didn't cooperate, he would destroy her in front of her kids by publishing old probate court records that he had acquired. The second charge under the wiretap statute is that at that same time, he recorded their conversation unknown to her and without her permission. The first time she found out about that she was being recorded when it was published on his website, and then found out that the conversation that was published on the website was not the conversation that she had had with him, that it had been altered. Since that time, the police have received a copy of a recording that does reflect what was said, which indicates that she did not consent to the recording. The reason that we're looking for bail is obviously the charges are serious. The intimidation charge is a felony. It carries up to 10 years imprisonment. The wiretap up to 5 years imprisonment. It's clear that the defendant has the proclivity for continuing with intimidation even after being charged and being on personal recognizance for this. We think the bail and the stay away and the monitoring is necessary just to ensure the safety, protection of the witnesses, at least until the trial of Karen Reed can take place, and to preserve justice and prevent it from being obstructed. Those are our reasons, Your Honor.
All right. Thank you very much, Mr. Novak. Attorney Bradel.
Your Honor, just some particulars. Mr. Kearney's 42 years old, Your Honor. He has two children, ages 6 and 8. He was an 11-year veteran of the Dudley Regional School District as a history teacher. And as you know, Mr. Kearney now operates several websites and news sites that he engages in very prolifically and provides all sorts of investigative reporting to the public and to his many followers that he has. And I just would note, Judge, that he's got a courtroom full of supporters here who think very highly of him and appreciate very much all of his activism and protest and journalism. So that's his current occupation, Your Honor. With respect to these two charges, Judge, this case was the subject of an order from Judge Crump on the initial bail determination of personal recognizance with no terms whatsoever. Judge Crump obviously was confronted with the very same issues, the same Norman issues, Cummel versus Norman issues, and he did not do anything whatsoever with respect to any stay-away orders. In this particular case, Judge, there are complicating factors with respect to what might otherwise be an order in another case. Here you have a journalist who is practicing his craft and is protected by the First Amendment, Judge. And if the court were to adopt the government's request wholesale, his choice of topics, which is the Karen Reed murder case, what would happen, Judge, is that anytime any of these witnesses decided to go and attend the Karen Reed murder case, they would essentially have a veto power over Mr. Kearney covering the case. So that was raised in front of Judge Crump. And ultimately, Judge Crump at the arraignment, not at the bail appeal, but at the arraignment, Judge Crump erased any restrictions whatsoever.
Mr. Bradel, with respect to the 8 or 9, I think it's 9 with the new indictment, Mr. Novak, witnesses that Mr. Kearney is alleged to have intimidated or interfered with, are there any restraining orders in effect?
No, Judge. In fact, 2 of the complainants tried to seek a criminal harassment order in the Stoughton District Court.
I mean a 250-80?
A 250-80 order, yes, Judge.
Okay.
Thank you. And they were both denied on First Amendment grounds. That was one by Judge O'Malley at the time, one by Judge Walsh.
What about Ms. Gaetani, who I understand is the alleged victim in another district court matter?
Yes, that's correct, Your Honor. And
she has a restraining order?
She has a restraining order that's in effect for a year. And in terms of that case, Your Honor, Judge McCallum in the district court set a personal recognizance bail on that case, this new case that we're arraigning now that's been brought to Superior Court. And I know the court's well aware, just the mere fact of an indictment is not a grounds for an increase in bail, but just because the government has unilaterally decided to put him in another court. It's the same case. In fact, it's actually a little bit better in the defense category. I've provided one of these to the Commonwealth, and it's come to our attention that the complainant who's gone to court and gotten a restraining order saying she's afraid of Mr. Kearney, doesn't want any contact with him. This morning at 1:55 a.m., she called him. She should know that he's incarcerated. And obviously he did not speak with her at all because he's incarcerated, but she called him on a Facebook Messenger video call at 1:55 a.m. No one spoke with her. We have custody of his phone and we've screenshotted and memorialized that call. This is someone who on the one hand is claiming one thing. Every single factual allegation here, Mr. Kearney absolutely denies 100%. And in fact, a lot of it is contradicted by the written record that will come to light. And it's been provided in the lower court, the text record where Ms. Gaetani contradicts her later statement to the police is contradicted by her text record where she invites Mr. Kearney over. She uses this new case where she's received a subpoena to lure Mr. Kearney over. And like moth to a flame, like a journalist to a new set of facts, he went over there at her invitation to look at everything that had been arrayed against him. Perfectly normal human impulse to go want to see what people are saying about you. And he followed her invitation to go over there. That's how the facts of that are going to show.
All right. You have a copy of that, Mr. Novak?
I did.
All right,
Ron has
Mr.
given me
Officer.
a copy of the
Yeah, Your Honor.
Well, as you know, Counselor, sometimes persons who have restraining orders reach out to the persons who are prohibited from contacting them. Your client should be advised that notwithstanding whether or not this individual reaches out to him, he may not, under the terms of that restraining order, communicate with her. Is there anything else that you want to bring to my attention with respect to the bail the Commonwealth seeks and/or the conditions of release?
Judge, I just want to note that the new case was personal recognizance with a restraining order already in place. The old case was personal recognizance with no conditions whatsoever. I'm asking you to return Mr. Kearney to the status quo. There's no problems. There's no issues. There's never been any problems with violating any court orders. And Mr. Kearney just wants to make sure that he doesn't give, that the court, he hopes that and respectfully invites the court to not give these witnesses veto power over him being able to investigate the Reed case by just virtue of just showing up.
All right. APO Mejia, do I have a carry?
Yes.
Oh, thank you so much.
So we would ask you to return it to the status quo, Your Honor, in all respects.
All right. Thank you.
Thank you.
Mr. Novak, this defendant has no real prior record, correct?
That's correct as far as I know.
And no real indication that he's ever failed to appear to answer charges against him.
I believe that's correct as well.
After having heard argument and understanding in particular that bail is necessary, cash bail is necessary only to ensure the defendant's appearance to answer the charges against him, I will not require a cash bail from Mr. Kearney. He will be released on his personal recognizance with no additional conditions. Mr. Kearney should be reminded, Mr. Bradle, that if, and he will be formally by Mr. Clerk, that if he is charged with any additional crimes, certainly there will be another revocation period.
Thank you, Your Honor.
Okay? The condition of release on personal recognizance is not committing any additional crimes. Mr. Clerk? Actually, we have one more thing to address, which is, Mr. Bradle, you had filed this motion to strike, motion for remedial orders and sanctions. Is that now moot given my decision with respect to the motion that the Commonwealth had brought?
I don't believe it is, Judge.
Do you intend to press it?
I do intend to press it.
All right.
In fact, I wanted to provide the court, and I'll provide the court on Monday with some of the physical evidence of the result of the behavior.
All right.
So-
Well, Mr. Novak, I know that I had ordered a deadline to respond. Does the Commonwealth need more time?
They do, Your Honor, because I'm not even aware of that.
All right. So here's what I'm
You
going
don't
to do.
object to any more time.
Yeah, I understand that Mr. Mello may be ill. What I'm going to do is set a deadline of a response to this motion to strike of March 8th.
He's in the hospital now, so I'm not sure. Your Honor.
I absolutely understand. I'm just giving a date so that we have one. But if you need more time, we'll get to it. Okay?
The next day we have is 4/23.
4/23, okay.
When we get the opposition from the Commonwealth to your motion, we can schedule a hearing.
Thank you so much, Your Honor.
Mr. Kearney, you're being released on your own personal recognizance. Please be advised on personal. If you're arrested for a new crime, you can be held without bail for up to 90 days. And your failure to appear at a court appearance will result in a fine of up to $50,000 and/or 5 years in jail. You must abide by all state and federal laws. Your matters continue to 4/23/24 for the purposes of a pretrial hearing. Thank you.
Thank you. Thank you very much.
Thank you.
Good afternoon, Your Honor. Alan Jackson on behalf of Mr.
Good afternoon, Mr. Jackson.
Good afternoon, Your Honor. Elizabeth Little.
Good
Also,
afternoon.
on behalf of Ms. Reed.
Good afternoon, Ms. Little. Okay.
We are back on the record. This is in the matter of the Commonwealth versus Aidan Kearney.
Hello, Your Honor. Timothy Bradle on behalf of Mr. Kearney, President Court, for the record.
With dates of offense of February 26, 2024 in the town of Dedham, you are charged with one count of violation of an abuse prevention order. A not guilty plea will enter on your behalf on that.
Any issues from the Commonwealth?
All right, Your Honor. We have two motions.
As these are arraignment motions, I'd like to be heard on a motion to dismiss prior to.
Yeah, does the Commonwealth want the defendant arraigned?
Oh, yes.
Yeah, so he's going to be arraigned and the Commonwealth's the moving party. As far as the order for pretrial, motion for pretrial detention, it does qualify under the statute, so the issue is one of probable cause. Are you going to be contesting the probable cause, Mr. Bradle?
Yes, Your Honor.
I'll hear you, Mr. Mello, on the pretrial detention motion.
Your Honor, this new charge before the court is one of an ongoing series.
I'm focused on this probable cause. I'm not interested in the ongoing series.
What we have here, Judge, is too voluminous to read to the court, Judge. This is a police report. What stands out among everything else, is the fact that Mr. Kearney was aware that the party to whom the abuse prevention order was given was across the street at the Superior Court. He walked in the courtroom. She was present. He did walk out. However, he then walked across the street, certainly within 100 yards of the Superior Court, and he stayed there as the victim in the abuse prevention order left the Superior Court. He was well within 100 yards of her. For whatever reason he had to be there, he was aware of the fact that there was an order. He was aware of her presence in the building, and he remained there. This defendant never acts in an abundance of caution.
The only issue isn't the abundance of caution, it's whether there's probable cause. Focus on that.
There is probable cause, judges, within 100 yards. Mr. Kearney was within 100 yards of the individual. He was aware that she was present. He did not make any attempt to go beyond that 100-yard limit, and he stood there as he watched her exit the building. The police report certainly states clearly that he was within 100 yards of her, and knowing she was present, it was his obligation certainly to get some distance between them. He did not do so. I believe that's the probable cause in this matter with respect to the charge being brought.
Let me ask a different question. Are you ready to go forward on that today? The pretrial detention?
I would prefer, Judge, the 3-day period allowed for a reason. I received from Mr. Bradle's office after 6 p.m. yesterday a large motion with several videos in it that I need time to review and have perhaps my investigator follow up on a couple of those things that we saw in the videos. Had I had that in advance, I would not have done so.
What about this afternoon?
It does not give me enough time, Judge.
This is a one-count case of a violation of a restraint. The government gave me 68 pages yesterday. It's not the kind of case that the government should come in here on a misdemeanor charge that should have been the subject of a clerk's hearing, and I appreciate that you put that aside for me, and then ask to lock my client up, which you know is the next request, for 3 days while they look at videos. Judge, this is a minor case that should not warrant a presumptive 3-day lockup of my client. There's absolutely no good cause based on the minimal nature of the case. Everything's on video. It takes 5 minutes to look at a video. I've looked at all the videos. I'm sure the court's looked at all the videos. Well, they're on file, Judge, and I know you will at some point. But they are 5-minute videos across the street at the Norfolk County Superior Court. The allegations here are completely lacking in probable cause, and counsel notably has cited to not one piece of evidence.
Well, are you contesting let's separate when the hearing is going to happen from whether there's probable cause. You're contesting the probable cause?
We're contesting probable cause, Your Honor. We're also...
Give me an example of why there isn't probable cause.
Sure, because in this case, it's on video. So this isn't one of those cases where, the government can hide behind the notion of, well, he says this, but we say that, so it's a factual issue. Here we have video. We have video of Mr. Kearney in the courtroom.
No, I'm not talking. I'm talking at the clerk's level of issuing the complaint.
Yes.
Are you saying the police report doesn't equal probable cause?
I'm not saying that, Your Honor.
So there is probable cause?
No, there is not.
No, as far as what the clerk did, that's the only standard here.
No, Judge. We're talking about 21835A, the exceptions, whether the clerk's office was able to deprive Mr. Kearney of a clerk's hearing for a non-arrested misdemeanor, whether the exception that they chose to use applies.
That's different from the probable cause standard, Mr. Bradle. Is there anything about the facts that alleged by Mr. Mello that are inconsistent about where your client was relative to where the alleged victim was?
Absolutely.
And that's in the police report, that distinction?
No, Your Honor. What I'm saying is that if Mr. Kearney's rights to a clerk's hearing were afforded, we would have presented evidence that the case lacked reasonably trustworthy information that the magistrate could rely on based on video.
Yeah. No, I don't want to merge the clerk's hearing issue with the probable cause for the pretrial detention.
Yeah, there's no probable cause, Your Honor. This case has no probable cause. We're prepared to do a hearing. We have 2 officers here today. We have our evidence that we've provided, and we're ready to go. And I don't want my client locked up for 3 days.
No, I know, but that's different than the clerk's hearing issue. That's what I'm going to do. I'm going to review the police report with the magistrate. If I find there's probable cause, we're going to do the dangerousness hearing today, whether this morning or this afternoon. Further call.
Further call. Commonwealth versus Aidan Kearney.
Counsel.
Reviewed all the submissions. Any witnesses for the Commonwealth?
No witnesses, just presentation and documents, Judge. I apologize. I have not had these this morning. I've shared them with my brother already.
It's all right. So there's more things for me to look at?
Yes.
Give them to me, but you don't have any witnesses.
No witnesses.
Do you have witnesses, Mr.
I have two
Green?
officers, Your Honor.
Is one of them Officer Crump?
Yes.
Mr. Miller, have you reviewed the submissions by the defendant?
Yes.
Have you spoken to Officer Crump yet?
Yes. No. I have not spoken to Officer Crump.
Don't you think you should?
Not really, Judge.
All right, give me your submissions.
And Judge, just whenever you're ready for it, we have several objections on relevancy grounds to a lot of that, but just wanted to put that out there.
The good news is if it's not relevant, it's not going to help anybody.
Okay. Self-executing objection then.
All right, thank you.
Thank you.
All right, why don't we assume that I've reviewed these already? Oh, no, you call your witnesses now, I'm sorry.
Certainly, Your Honor. I would first like to call Judge Dedham Officer Matthew Kozak.
Good afternoon, officer. Could you raise your right hand? Do you solemnly swear in this matter now in hearing to tell the truth, the whole truth, and nothing but the truth, so help you God?
Officer, please state your name and spell your last name for the record.
Matthew Kozak, last name Kozak.
And give us your profession, description, and a little bit about yourself.
Dedham police officer, been with Dedham Police Department for 10 years now.
Next question.
Directing your attention to 22624, it's been brought to your attention that you went to an alleged vandalism call right here in Dedham at actually the back parking lot behind the registry, correct?
Correct.
What's the first thing you recall about that incident? How did you come to be asked to go there?
I was dispatched, I was on a call at the time on Route 1, I was dispatched to call mine here. And when I got on scene, I noticed a fair amount of people, 4 or 5 people standing around the vehicle, and I could immediately tell that it was damage to the driver's side vehicle, to include the rear tail lights.
What was the nature of the call, first of all?
Malicious damage to a motor vehicle in the back of the registry of East parking lot.
Can you recall that the time you received the call was 2:32 p.m.?
I'm going to dispute that around that time probably.
And you record that in your reports, right? And the report says 2:32, so that's what it would be, right?
Correct.
And the report also says 2:47 cleared.
Correct.
And that means that when the call's over, right?
Yes.
So you're out of there about 2:47 p.m. you're out of there.
Yes.
So about 15 minutes you spent with the complainant, right?
Correct.
Did she indicate to you anything about where she had been and what she was doing?
Just that she had come from Superior Court, I believe, that's
Sure.
and then when she got back there, Carmen.
And she was with a group of other people as well, yes?
Correct.
And were you able to ascertain who those other folks were, just in terms of why they were there? What was their relationship to the hearing or anything like
I
that?
didn't get in depth with them at all.
Okay. And as far as you knew, you were there to investigate a vandalism call, yes?
Correct.
All right. And what did you do with respect to investigating the vandalism call?
Once I completed that, that was towards the end of the day, so nothing that particular day. And the next morning, I had reached out to the Registry of Deeds to check their camera footage and the Norfolk Dedham Insurance Building, which is basically right next to where their car was, because they were parked all the way in the back of the parking lot.
Okay. So just to save you the time on that, you looked into some video around and nothing came of it, right?
Correct.
Okay. Just rewind back to the day in question and you're at the scene. Did you look at the car for supposed vandalism?
I did, yes.
All right. Did you take some pictures of it?
Correct.
All right. And you had a conversation with the complainant, right?
Yes, basically everyone, it was one big group that was there.
Everybody was sort of adding things and chiming in and talking to you, trying to give you information.
Correct.
And then afterwards you reflected in your police report as best you can.
Yes.
Did you ask the complainant, and that's Miss Lindsey Gaetani, correct?
Yes.
Did you ask Miss Gaetani anything about who might have an interest in doing something like this to you or anything to that effect?
Yes, that's standard.
What were your words? What did you
I can't remember
say?
exactly what I said, but if it be someone, is there anyone of interest or something along those lines that you may think would have done this to your vehicle?
Right, and what did she say?
And the consensus was that it could possibly have been Mr. Kearney or someone associated with it.
And did Miss Gaetani say anything relative to a restraining order?
So she did at one point say she had a restraining order, which is something I would want to know in this case.
Sure.
They say that.
Between 2:32 p.m. and 2:47 p.m., after leaving the courthouse, she went to the car, saw damage, told you that she had a restraining order against Mr. Kearney.
Yes.
Did she say anything about him taunting her, calling her a liar, violating the order at all?
Yeah, I don't recall anything along those lines.
You answered the question. Next question.
Okay. So if she had said something that important, you would have reflected it in your report, right?
Correct.
And we agree there's nothing in your report to the effect of anything about restraining orders, right?
Correct.
What was her mood at the time?
She seemed pretty quiet. She was sort of the furthest away from me out of the group, just sort of there. Yes.
Okay. What about all the other folks there? Were they also offering information too?
Not really. They were speaking, but none of it for my sake. What I needed to see was the camera footage, so that's what I was focused on. So until I knew, I wasn't going to speculate as to who may or may not have done this. I wanted to investigate it myself.
Sure. Did she say anything to you about Mr. Kearney violating the order she mentioned just prior to that?
Negative.
Did she say anything about him taunting her or calling her a liar?
Not that I remember.
And if you did remember, that's something that's so important that you would have either arrested the gentleman if he was around or certainly reflected in your report, right?
Correct.
And there's nothing to that effect anyway, right?
Correct.
Thank you very much. Nothing further. Your Honor.
Cross-examination.
No question, Judge.
Thank you, sir. Next witness.
Officer Matthew Kozak. Crump, I'm sorry, Crump.
Afternoon. Do you solemnly swear in this matter now in hearing to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Officer Crump, please state your name, spell your last name.
Officer Brian Crump, CRUMP.
And you're a Dedham police officer?
I am.
How long have you been so employed?
25 years.
And you've been asked questions in the last couple of days and last week regarding an incident that happened back on 2/26/24, right?
Yes.
And the incident involves you as a Dedham police officer on duty, correct?
Correct.
And tell us what your assignment was just in general that day, that afternoon, after 2 o'clock.
I was assigned outside, basically to make sure pedestrians didn't get struck. Crosswalk between Red Street and Eads and Spirit.
Sure. And there were a lot of people milling around that day, yes?
Yeah, definitely the busiest crosswalk in Devon that day.
Yeah.
We were very busy, making sure no one was out here.
Okay. And there was a hearing that day relative to the case involving the Commonwealth versus Karen Reed in Norfolk Superior Court, correct?
Correct.
Your assignment was to direct traffic in the crosswalk.
Correct.
At some point, did you encounter the gentleman to my right?
I did.
And for the record, who is this and where did you encounter him?
Mr. Kearney. I saw him coming across from Superior. So when people got close to the crosswalk, I stopped traffic, which I did. And then that's when we approached across the street as I was crossing the limit.
And what would you say his mood was as you were able to observe at the time?
His mood?
Happy, sad, confident, angry, upset?
It was a brief conversation because he seemed like he was kind of irritated that something had just happened and he was trying.
Right. What did he tell you?
He said that there was someone with a restraining order against him and he within 100 yards. And I think I said, I don't know who you're talking about or where they are. And I think he said they're in court, in the Superior Court.
Was he looking to you for guidance or what to do about it?
Yeah, I think he, as he was coming across the street, I remember kind of turning with him, and I think he said something about moving away. I interpreted he wanted to go far enough away not to be a violation of this person. I don't even know who this person was. He didn't say who it was. He said a person.
Sure.
So yeah, he was moving away toward the registry of deeds, and yeah.
And where did he go after that, to your observation?
I kind of remember him heading up toward like maybe the steps or toward like Ain Street, like in that corner of the building, but I actually didn't see exactly where he was.
Sure. Recognizing that you're very busy in that intersection, and I think we all know how that intersection is on days like this.
Once he cleared, that's when I could stop traffic.
Yep, sure. He gets through. At any point in that afternoon, did you notice him any further that day?
I did.
Okay. So it's fair to say you didn't hear him yell liar to anyone or taunt anyone or anything to that effect, correct?
What's the grounds for your objection?
Judge, he's basically testifying.
No, he's asking him a question.
Not
Overrules.
Oops. I don't recall that, but I mean, it was noisy, a lot of people, but I don't specifically recall those words.
Would you say that Mr. Kearney was trying to circumvent the order or making a good faith effort to comply with the order, based on your observations?
Based on our brief
No offense,
conversation.
witnesses' opinions don't count.
Thank you,
Next
Your Honor.
question.
Nothing further.
Fact-based,
Nothing further. Thank you.
cross-examination.
Sir, your interaction with Mr. Kearney took about how long?
Seconds at the most.
6 seconds. And after that, you weren't directly watching everything he did, every move he made, correct?
Unfortunately, he didn't have my undivided attention at the time. He was in the middle of something, but no, I didn't watch him.
So you interacted with it for 6 seconds. Okay, thank you.
Nothing further, Your Honor. Thank you.
Thank you, sir.
Thank you, officer.
Any other witnesses?
No witnesses.
All right, any other submissions?
I have submitted quite a few documents, Your Honor.
You just submitted these.
Yes.
And I already reviewed the other submissions. Anything else?
I have a thumb drive, Your Honor, and what I understand that thumb drive depicts.
No, you don't have to give an opening. You want me to look at the thumb
Yes.
drive. Are there any other things either party wants me to look at before we give finals?
I'd just like to make sure that I have a copy of what's on that thumb drive.
All right, got it. Anything else? All right, so I'm going to take a short recess, thumb drive, the new submissions.
Yes.
We'll make sure you have a...
Thank you, Your Honor. And I do have 3 quick affidavits I'd like to submit, Judge.
I'll hear from you, Mr. Mullins.
Your Honor, the basic facts are pretty clear. Mr. Kearney was across the street from the Superior Court when Mr. Kearney left the building. He had a 6-second interaction with an officer and said, am I okay here? Officer said, yes, you are. There was no further discussion about when somebody came out, when somebody walked by, or whatever the case may be. Here, the photographs provided to Your Honor clearly show Mr. Kearney at different locations in front of the Registry of Deeds. And it's clear that he's following and photographing Ms. Gaetani from his location, including hiding behind the bushes, hiding within the bushes to photograph her as she left Superior Court. He was easily less than 100 feet away. I believe one of the measurements Your Honor has shows he was 75 feet away from her location. He knew exactly what he was doing. Mr. Kearney is not one to act out in an abundance of caution, Your Honor, but he pushes the envelope as far as he possibly can consistently. If I may, Judge, before I forget this, Your Honor was presented with purported to be text messages from Ms. Gaetani to Mr. Kearney that were recently allegedly made. Ms. Gaetani would surrender her phone to the court for purposes of evaluating whether or not her phone sent those messages. She absolutely denies it. And the fact that...
That really isn't part of the evidence. You were, a little while ago, objecting to affidavits. They're hearsay. This isn't even hearsay. So you're not going to argue things that weren't in here.
That was submitted to Your Honor.
No, you just told me about what the evidence is. That what you just said wasn't part of this. Go, stay with the evidence.
The evidence is, Judge, that Mr. Kearney knowingly was less than 100 feet away from Ms. Gaetani on several instances during the course of the afternoon. He knew she was there. He knew there was a restraining order ordering to stay 100 yards away.
Where's the danger?
There doesn't have to be danger, Judge. No danger whatsoever is required. The order...
For pretrial detention?
Oh, in terms of the pretrial detention, I thought...
That's the motion you were arguing?
For the pretrial detention, Judge,
yes.
The danger is that Mr. Kearney has consistently harassed this woman online, continues to do so today. Your Honor has a...
Where's the physical danger?
Your Honor has the thumb drive, where Mr. Kearney is saying, I will be far more dangerous when I get out. When he made that statement when he was incarcerated, I will be far more dangerous when I get out. He has a number of instances here, Judge, where in the context of the documents that you were given, he has set up a Pornhub account. He set that up himself. Aidan Kearney at Pornhub for Ms. Gaetani.
Physical danger.
It doesn't just, it's not just limited.
For pretrial detention, it's a physical danger standard.
Judge, the physical danger is that he keeps stalking this woman. We do not know what's in his mind, what he's going to do. If he can't follow the court's order, Judge, and has historically not followed court orders, there is a danger there. We don't know what's going through his mind. Why anyone who would violate an order so consistently as he has, I mean, he speaks about his, in some of the documents I gave you, Your Honor, about his mental issues, saying he doesn't have a gun because he doesn't know what he would do if he had one. Those are all big concerns. And I mean, he has a car. God knows he can get his hands on another weapon. And he continues to stalk this lady, continues to harass this woman online. It's almost on a daily basis, Your Honor. And she is terrified. She's absolutely terrified of this man. In terms of the danger, that's basically the danger, Judge. He's had a number of people who he's intimidated, according to the grand jury, several cases, outstanding charges now of intimidating a witness, conspiracy to intimidate witness, and with respect to this particular individual, Judge, Mr. Bradle came before this court, and I'm not in any way suggesting that Mr. Bradle was aware of this, but he came before this court and presented a recording that purported to start with this defendant saying, I'm still recording, and then a long conversation, if you will, between the defendant and Ms. Gaetani. This defendant was subsequently indicted for illegal interception and oral communication with respect to that. And the Commonwealth has...
That's not physical danger. Focus on physical danger because you're asking me to hold him because he's too physically dangerous. Go.
I believe he's physically dangerous, Judge, simply because of what I've indicated to you.
Right.
The fact that he consistently goes after this woman, those are not the actions of a normal mind. To continue to harass somebody like that, to continue to follow them, to stalk them in front of this building, those are not normal reactions. Okay, and Judge, that suggests the physical danger. In addition to all of the other charges he's amassed, there is a physical danger, Judge. This is a woman who came before this court, obtained a restraining order, indicated she had been assaulted by this individual, and basically she's terrified. That's the physical danger, Judge. The physical danger is created by him and his actions and his stalking and everything else. And when somebody says, I don't own a gun because I have mental issues, compounded with his stalking her, that's a physical danger.
Thank you, Mr. Brady.
Your Honor, thank you very much. May it please the court. Judge, there's no danger here in addressing what Your Honor is talking about. He has no record. This case involves an alleged being within a sphere of distance. She came into his distance, Your Honor. He left. He tried to avoid it. And in fact, the record shows, and I'm sure you picked this up, Judge, she didn't see him, he didn't see her. He constructed this thing later on. And then you can see in the 68-page filing as well, she changed her story when she realized that Mr. Kearney went to the police and showed video to the police wherein she doesn't react to him, according to the officer. She doesn't know he's there. Then she writes the 68-page thing contradicting herself, saying, oh, maybe it wasn't him. Maybe I didn't hear him say that. I'm not sure. Okay. So she said it at the time because she knew that she had to say that he tried to contact her at the time. And it's an absolute lie. She got caught lying. She's an absolute liar. She's a deranged individual. Counsel talks about stalking. Stalking has a legal definition. The only person that can make out the legal definition of stalking is her on Mr. Kearney. Mr. Kearney's never been dangerous. He's never harmed anyone. He has no issues with harming anyone. All he's ever done is tell people to tell the truth. Everything else in their submissions, Judge, involves that they don't like his journalism. Everything else is completely baseless, absolutely not a basis to establish any physical danger whatsoever, because Mr. Kearney, his entire life, has never been a dangerous person in any way other than his journalism, frankly. So that's what we're talking about here is the government and Ms. Gaetani, working in concert, have tried to do nothing but suppress his journalism under this phony guise that he's dangerous. And incidentally, Judge, counsel didn't address this, but this court had an assault and battery complaint against Mr. Kearney. The government didn't even indict it. It was so flimsy. They abandoned it and left it here, and it was null prost. The allegation was that Mr. Kearney was struggling with Ms. Gaetani for about a second, trying to get his notes back that she took from him, and that she fell onto the couch. That was the only allegation anywhere in the galaxy related to Mr. Kearney about alleged violence, and they abandoned it. Thank you, Your Honor.
I appreciate arguments by both counsel. After hearing review of the evidence, the motion is denied. The defendant's going to be on personal recognizance. Contact with the alleged victim. You want to be heard on your motion?
Folks, quiet, please. Your Honor.
All right. Mr. Barboza, if anybody does that again, they're out.
Yes, Your Honor.
Go ahead.
Your Honor, with respect to the motion to revoke bail, Mr. Kearney has two separate, if you will, sets of charges pending in the Superior Court. He was given the regular bail warning when he was released from the Superior Court on personal recognizance. He has managed again to have additional charges brought against him in this court today. Your Honor found probable cause for those charges, and I suggest that is sufficient, Judge, for this court to revoke Mr. Kearney's bail for a period of 60 days on both of the cases that are pending before the Superior Court, and I would ask Your Honor to do so.
Mr. Brady.
Your Honor, the government's argument flounders on the same rocks. There's no issue of future danger. He's never been dangerous. There's no risk of danger. There's no danger alleged in this incident here. This also implicates, Judge, the quality of the allegations. And that's roundly addressed in all of our submissions, that this is based on lies, that she is caught lying, that Mr. Kearney violated the order by yelling at her. Everything else in the case shows that he was trying to avoid contact in total good faith, trying to stay away from her. And she came into his sphere. She came into his courthouse. Thank you, Your Honor. Nothing further.
All right, after hearing that motion is denied. Mr. Brady, you want to be heard on the motion to dismiss, is that right?
I do, Your Honor.
All right, and you're ready to be heard on that?
I am, Your Honor.
All right, I'll hear from you, Mr. Brady.
Thank you very much, Your Honor. So, Judge, typically in this situation, and I think the situation speaks volumes about the quality of the allegations, Your Honor.
But just to make sure both counsel understand what I'm going to be reviewing, it's a snapshot of what the magistrate had at that time. There isn't like the equivalent in the civil world of a motion for summary judgment.
Judge,
this is the snapshot at that time.
Yep. Okay, I appreciate that, Judge. I want to back you up, if I may, respectfully, back to when the officer approaches the magistrate for the issuance of process. What do we have? We have a misdemeanor where he's not subject to arrest. 218-35A specifically says that he's allowed to have a clerk's hearing in that circumstance. There are 3 exceptions. Here, if we look to the paperwork, you'll see the paperwork does not make a finding that satisfies any of the exceptions. If you look at the bottom of the page, it's from the file indicating application for criminal complaint, Your Honor. And you'll see at the top, the officer, or the boxes that purport to be the officer asking the court something. On the top, it says only misdemeanors without notice, commission of a crime, and that's what's checked on top. So then the magistrate receives the documents, and the magistrate here deprived Mr. Kearney of a clerk's hearing. So you have to see if the circumstances and the findings, these boxes on the bottom are the magistrate's findings, and the magistrate's findings do not reflect the exception that they're trying to use. The exception is no clerk's hearing when there's an imminent threat of a crime, of a future crime, the commission of another crime, not the crime we're looking at here, a future crime. So it's 2 things. It's threat of a crime, but an imminent threat of a crime. And as we know, statutes and words in statutes need to be given their ordinary meaning, Your Honor. And the meaning of imminent, and I'm going to read it because I don't want to get it wrong.
Well, the alternative for imminent is either bodily injury, crime, or flight by the...
Right, but look, the only thing that they've checked is crime.
Right, well, so it's implicit that it was one of those 3 options for imminent threat.
It's not, it's an incomplete finding, Your Honor. It says applications decided without notice to the accused because it just says crime. Crime itself is not a basis.
Argue the merits instead of that technicality of a box, because the crime box is checked off.
Right.
I see what you're saying.
Sure. Imminent threat is not checked off, Your Honor. They have to make that finding. The finding not made. It's not a close call, Judge. They have to make the double-pronged finding. Imminent threat of the commission of a future crime. This is the government's documents, Judge. We're not here to speculate on what is the government, what do they mean? Okay, that's not part of this. They're trying to lock up my client here. They're trying to deprive him of what I say is his due process rights.
It was a summons. This is a summons, not a lockup. Go.
When I say that, I mean broadly the government, including the prosecution. The court is trying to deprive him of his right to a clerk's hearing. That's what this is about here. And I'm sorry to speak broadly. I mean that the court's not trying to lock him up. The government as a whole is trying to lock him up. But here the court is trying to deprive him of his clerk's hearing. And the court did not make the proper finding. The court has boxes here. If there's an imminent threat of the commission of a future crime, they need to make the finding there's an imminent threat. They did not make that finding. Mr. Kearney is entitled to dismissal, and if the government wishes to commence this thing, get this thing off the ground again, let's bring it on, but let's do it at a clerk's hearing, which is what his right is, Judge, because the clerk's hearing performs so many valuable functions here, Judge, and you saw my filing, I'm not going to reiterate, it's in the triple own case, but also, Judge, clerk magistrates have to rely on, and they do, I see them doing it every day, rely on reasonably trustworthy information is probable cause. And so here, there's no reasonably trustworthy information, and Mr. Kearney was deprived of the opportunity to present that to the court and say, look at our video. Look at what she said in the report. She said that Kearney yelled liar. She said that Kearney was screaming at her and that she saw him and that she perceived him.
The magistrate didn't have that information at the time that the magistrate found that there was an imminent threat of a crime.
Right.
I know you're saying, but she didn't check off the first box. It's implicit that that's what it was. Go ahead.
There's a box to okay, I'm not going to argue with it. Right, you're the judge. You make your finding. I appreciate that. I respect it. In terms of the merits of the case, Judge, the merits of the case don't speak to any future danger. They don't support a finding that Mr. Kearney is likely to cause imminent, serious future harm to anyone.
No, just a crime. See, in other words, the magistrate didn't check off the bodily injury, Mr. Brado. The magistrate checked off the crime.
Right, and didn't check imminent threat.
Obviously, from your point of view, is he has these charges across the street.
Yes, the charges across the street, Your Honor, are based on emotional harm. The witness intimidation statute, as I'm sure the court's well aware, 13B, says emotional harm. All of these...
But this isn't... The magistrate didn't check off bodily injury.
Right. I'm sorry, Judge. I'm sensing that you want me to not argue anymore on the imminent threat issue.
Well, no, but on it's the threat of a future crime that the magistrate found.
Imminent threat, Judge.
Yeah.
They did not find imminent threat. The box is not checked. So we can't speculate that, oh, they meant to check imminent threat. You're filling that in, Judge.
Well, there's no other reason to fill out this form if that's not what it was.
There's a box to check when they need to make that finding. So they didn't make it finding. That's my argument. Putting that aside, Your Honor, whether we revoke the bail, the quality of the allegations are relevant and matter. And the quality of the allegations, I think, have been alluded to and vetted out here. And the quality of the allegations, whether you would lock someone up for this case on a bail revocation, is ridiculous in the sense that the case is shown to be false. Ms. Gaetani went to the police and said, he was telling me I was a liar. And then she backs off it in her 68-page submission, only because Mr. Kearney called her out on it, and because we had video, thankfully. And so that's the lack of quality here, Judge. And especially the other thing is the nature and circumstances of the offense, in the sense that this type of a crime for someone with no record would never result in Mr. Kearney going to jail. So it would be deeply unfair to Mr. Kearney for the court to lock him up pre-trial on a case where he's not dangerous, on a case where he wouldn't go to jail. So again, I ask that you not revoke any bail and that you allow him personal recognizance. Thank you.
On the motion to dismiss.
Your Honor, Obvious Commonwealth objects to the motion to dismiss. The facts are clear. Your Honor found earlier indicated on the record the probable cause to bring this charge. I believe the clerk magistrate's office acted appropriately in issuing the summons to appear today. Your Honor reviewed that earlier, and I would ask that the motion to dismiss be denied and this matter go proceed in the normal course.
All right. I appreciate the defendant's motion.
Thank you,
It was fine that the magistrate was justified in checking off the crime box, which was implicit of threat or a reason of depriving the defendant of hearing. So after hearing that motion is denied, and if I wasn't clear, the motion to revoke has been denied.
Oh, okay, thank you.
As well. So here we go. What date for pre-trial? And here you go.
Where would the court be in general, Your Honor? Like May or?
Like April, May.
All right, so on docket 2454 CR 0255, after hearing on the Commonwealth's motion for pretrial detention based upon dangerousness and Commonwealth's motion for an order of bail revocation based upon new charges, after hearing those two motions have been denied, sir. On this new docket, you are being released on your personal recognizance. That's your promise to return back to this court on any date in which the court orders you to do so. Condition of your release, you're ordered to stay away from and have no contact with any victim in this matter. I must advise you that if you violate that condition, or if you are arrested with or charged for another criminal offense during the pendency of this case, your bail could be revoked and you could be held without bail for a period not to exceed 90 days. After hearing on your motion to dismiss, sir, that motion has been denied. Your case is going to be continued to April 26, 2024 at 9 a.m. for a pretrial hearing. Your presence will be waived on that date. Please check in with the probation department before you leave here today.
Thank you.
You're all set with us.
Thank you.
Thank you.
Thank you.